I'd like you to imagine you're the complainant in a rape trial. Your family are here, everyone is staring at you, judging you. You're facing giving evidence about intimate details of your life and being grilled in cross examination. In the end, you'll either be branded a liar or a victim. How would you feel?
I'd like you to imagine you're being tried for the offence of rape. Your family are here, everyone is staring at you, thinking the worst of you. You're facing giving evidence about intimate details and being grilled in cross examination. In the end, you'll either be acquitted or branded a rapist. How do you feel?
This is clearly an emotive topic. Today we're going to discuss three main areas in relation to serious sexual offences and how they are tried. We will particularly focus on social media and jurors, restricting the access of the public in serious sexual offence trials and anonymity in light of the Gillen Review. As you may be aware, Lord Justice Gillen produced a report into the law and procedures in serious sexual offences in Northern Ireland, known as the Gillen Review. Lord Gillen published over 200 recommendations within a preliminary report, research for which considered the complainant's journey from the initial complaint through to the point of court disposal. The review was prompted by a greater level of public awareness in the recent high-profile rape trial of rugby players in Northern Ireland. Gillen explained in an interview given at the time the review was published that many of the issues brought to the public's attention during coverage of the trial had been long recognised within the legal profession. He said that the need for the review of how the criminal justice system deals with these cases predates the recent trial. Gillen pointed to recognisable defects within the criminal justice system in relation to existing law and procedures around serious sexual offences. Gillen's review highlights 16 key recommendations. These include raising public awareness, restricting public access to trials, anonymity, and tackling social media use. We will now look at some of the key issues and discuss some lessons to be learned from Gillen's review.
Restricting access of the public to the courtroom. Firstly, we're going to consider whether the public should be prevented from attending trials relating to serious sexual offences. We must consider one of the most high-profile sexual offence cases in Northern Ireland, that of Paddy Jackson, Stuart Oldham, Blaine McElroy and Rory Harrison, referred to in the media as the rugby rape trial. This trial was held in Laganside Courthouse, which seats 100 people in the public gallery. The level of public interest in this case elicited was unheard of. Even the Northern Bank robbery trial and the double murder trial of Colin Hoyle saw at most half of the seats in the public gallery being occupied. In this trial, however, there were queues for seats in the public gallery every day. We want to consider what problems this poses. First and foremost, we must recognise the principle of open justice and the right of the defendant to have a public hearing. However, this right is not absolute. Serious sexual offences are unique as they delve into the soul of all that is private and intimate in the personal lives of the complainant and the accused. They elicit feelings of shame and self-blame, which are major contributors to the refusal of complainants to report these crimes. We need to think about why members of the public want to attend these trials. In the small community of Northern Ireland, where everyone is easily identified, the presence of even a few people is enough to render the identity of the complainant and the sordid details of the alleged offences a matter of public knowledge. The use of social media has made this danger even greater. It can be safely assumed that the vast majority of people who attend trials are doing so only for the scandal. For example, spectators tweeting regularly about what they have heard. The sheer extent of social media has made this impossible to control. Restricting the access to the public is a method of preventing details about witnesses' identity and untruthful information from being released to the public. Information coming from spectators at a trial can easily influence jurors and prejudice an ongoing trial. The Gillen report includes a survey which shows that out of 420 respondents, 86.7% agreed that the access of the public should be restricted in serious sexual offence hearings. In line with the Gillen report, we are therefore of the opinion that unless a person is directly concerned with the proceedings, a representative of the press, a friend, relative of the complainant or the accused, they should be prevented from attending the hearing. This is in line with the position in the Republic of Ireland, New Zealand and Australia, where the public are banned from attending rape trials. We also must address specifically the attendance of the press. It is well recognised that the media serve as the eyes and ears of the wider public, and it is in keeping with the principle of open justice to allow their attendance. However, the problem is that in recent years, certain newspapers have taken a sensationalist approach to reporting, giving a twisted view of the proceedings. People who are not in attendance read this, take it to be fact, and then spread this via social media. We therefore recommend that the press should be subject to controls as to what can be reported, how it can be reported, and when it can be reported to avoid sensationalist reporting.
All of you will no doubt be aware of the massive expansion of social media over recent years. There are currently 2.32 billion Facebook users, 1.9 billion YouTube users, 1 billion Instagram users, and 330 million Twitter accounts. The use of social media is now an integral part of the communication lexicon. It is commonplace to communicate and do research electronically through blogs and websites such as Wikipedia, search engines, Google, other social networking websites such as Facebook, LinkedIn, and YouTube. Social media used by jurors poses new challenges for the court from the increased risk of undermining the right to a fair trial. Juror misconduct using social media may have a direct impact on the administration, fairness, and integrity of the criminal justice system. Unlike evidence heard by a jury during trial, information a juror obtains online cannot be addressed by the court with a curative or limiting instruction to correct any prejudicial effect. Both the prosecution and defence are deprived of the opportunity to consider and address information obtained by social media by tailoring their case strategy or closing statement accordingly. Complication further arises in jury deliberations because the individual jurors will not be considering the same evidence in reaching a verdict. Many courts and legislatures have adopted remedies to supplement social media jury instructions. Suggested ways of addressing social media use to jurors may include showing a film to prospective jurors shortly after they report for jury duty, illustrating prohibited uses of social media, explaining why using social media is prohibited, and notifying them of the penalties that may be imposed. Legal counsel may use voir dire to ask prospective jurors or request a judge inquiry about their social media use and whether they would be able to comply with the judge's instructions prohibiting improper social media use. Voir dire may provide another opportunity to repeat the court's social media jury instructions and educate jurors at an early stage of the process. Although it is not a remedy used in UK courts, a judge may require that jurors be sequestered for the duration of the trial or jury deliberation. Another suggestion is to require that jurors sign a written statement, possibly under oath, acknowledging that they have been notified of prohibited social media use and agreeing to abide by the prohibitions. The threat of sanctions such as finesse and contempt may be helpful in deterring social media misconduct. The controversial case of footballer Ched Evans provides a recent example in which 9 people were fined by the courts after they admitted to naming the complainant on social media. It is perhaps noteworthy that all defendants appear to have claimed to be unaware that naming her accounted to a criminal offence. This highlights a potential lack of understanding by the jury on their obligation to protect the complainant anonymity. The effectiveness of judges' instructions to the jury on social media may be improved in a number of ways. Firstly, jury instructions should use plain and simple language and describe the prohibited social media conduct such as texting, emailing, tweeting, or posting. Many jurors do not understand what prohibited communications mean. Secondly, provide specific examples of prohibited social media conduct. This will reduce the likelihood of misinterpretation by individual jurors. Thirdly, explain the rationale for social media restrictions. Jurors who are provided with the rationale underlying social media restrictions are less likely to arrive at the mistaken conclusion that they have not run afoul of the court's instructions. Moreover, jurors will be better able to see the restrictions as meaningful and important rather than a boilerplate limitation on their conduct. Finally, describe the consequences of violating social media restrictions. To further impress upon jurors the importance of social media restrictions, courts should inform jurors of the consequences of failing to adhere to them, such as mistrials and disciplinary sanctions for jurors who violate the court's instructions.
Anonymity of parties to sexual offences. Currently, the law protects complainants' right to anonymity. The Sexual Offences Amendment Act of 1976 grants automatic lifelong anonymity to an individual who alleges that they have been a victim of rape. This protection has now been extended by subsequent legislation to certain other sexual offences. The result of this law is that it is a criminal offence to publish a complainant's identity or any information that might lead to a complainant being identified. The position for those who are accused of rape, however, is in stark contrast to that of the complainant. Only in exceptional circumstances is the disclosure of the defendant's identity prohibited, for example due to his vulnerability or if it would result in the identification of the complainant. Is it not wrong to deprive those who are accused of rape of the same protection that is afforded to complainants? If it is wrong, how far ought the law go to changing this position? It is arguable that crimes of a sexual nature fall within an entirely different category to most other offences. The stigma that attaches to rape and sexual offences, particularly those involving children, is enormous, and the accusation alone can be devastating. The experiences of public figures attest to the devastation of private life caused by media scrutiny. Among prominent cases are those of Sir Cliff Richard, who was accused of committing a historic child sexual offence, and whose home was subsequently raided by the police on live television, despite him never being charged or arrested. Public scrutiny threatens to undermine the concept of innocent until proven guilty, and that it is for the prosecution to make out their case. Supporters of defendant anonymity point to the inequality to which the distinction between complainants and defendants gives rise. Why, they say, do potentially innocent defendants not receive protection in the absence of their finding of guilt? The main concerns of opponents to defendant anonymity are that it would have a chilling effect on both the reporting of and the prosecution of rapes. Publicising the identity of defendants encourages other victims to come forward, and the current position promotes victim confidence in the criminal justice system and allows justice to be seen to be done. Notably, Stuart Hall and Rolf Harris are perhaps examples of men who might never otherwise have been brought to justice had their actions not been exposed to the public. In rape cases, the credibility of the complainant's account is often the basis upon which the prosecution case stands or falls. These offences are clandestine in nature, and there is often little corroborative evidence to support the complainant's account. Arguably, the publicity of the defendant's identity exposes the behaviour of repeat offenders that contributes to the credibility, and that in turn contributes to the credibility of the complainant. The publication of defendant identities has further exposed the prevalence of sexual crimes and the identity of repeat offenders, which has shifted the narrative away from victim blaming. The Me Too movement and its associated groundswell of support for victims of sexual violence and abuse have done much to highlight past failures to listen to complainants and to provide them with appropriate support. Actress Alyssa Milano posted on Twitter, "If you've been sexually assaulted or assaulted, write Me Too as a reply to this tweet." That came on the heels of stories by the New York Times and the New Yorker about allegations of sexual assault by Hollywood producer Harvey Weinstein. 24 hours after her tweet, Milano had 500,000 replies. Headlines about Weinstein and allegations against other prominent men dominated the headlines, not just within the US, but across the world. Normalising reporting by victims of sexual offences in this way has lifted the lid on the clandestine nature of sexual offences, creating a more accepting climate in which complainants can give evidence. Opponents also point to the fact that defendants are not granted anonymity in relation to other serious offences. Why then for rape cases? While one might accept that the current position fails to strike the right balance between parties, it is difficult to know how the law can be reformed to satisfy both sides. One suggestion is to provide generally for the anonymity of defendants in sexual offence cases, with a judge being able to make an exception and name the defendant if this were in the interests of justice, for example, to help identify other potential victims. Nevertheless, this is a complex and sensitive question to which there are no easy answers. Indeed, politicians have grappled with the question before and not been able to find a satisfactory solution. The 1976 Act, which first granted anonymity to complainants, provided the same protection to defendants, but these provisions were subsequently repealed. More recently, in 2010, the government committed to extending anonymity in rape cases to defendants, only subsequently to do a U-turn. Given the complexity and sensitivity of this issue, it seems likely that these debates will continue.